Good morning. Good morning, my friends. You guys are freaking out. Give me a little second over here, please. Little shenanigans going on this morning in court, so I'm going to play that back for you. In addition, they came back with a note from the jury. One of the jurors has a prior commitment and needs to be out of there by 4 today, so they said that it would happen, that they're going to let them out by 4 today. She also told the attorneys that she wanted everyone in the courtroom at 10, and then she wants them in again at 3:30, and they're only going to have 5 minutes notice to get back to court over there because they're just going to announce when the verdict is reached, and they're going to give them 5 minutes to get back to court, so they can't really go anywhere far. And I don't know what the weather is today. I didn't really get to catch any coverage this morning. I have 5 kids, as you know, and tonight is prom night for my twins. So this is a very, very busy day for me, and I'm doing the best that I can. So please take a step back and just relax. I have invested a lot of time and energy in this case with you guys for 6 months, and I'm going to be heartbroken if I'm not going to be here to watch the verdict with you live. But as always, my children come first, and it's a very big night for my girls. So that's what I need to be doing this afternoon with the prom pictures and everything else. So let's just take a look at what happened this morning. I'm a little mad about it, and I've been waiting to hear from Mark Bettero's on trial. We did a show together last night, so I did ask him his opinion on this, but like he's on trial, so he can't get right back to me. Although he did give me his thoughts on this. So what we do know so far today is 5 minutes notice on a verdict. Everyone's got to get back there within 5 minutes, and we know that a juror needs to leave at 4. So the latest they're going to go today is 4. So we just don't know what's going to happen. But let me show you what happened in court when they came back into the courtroom about a little while ago. Maybe it was a half an hour ago. I know the audio is going to be terrible. It's Boston 10. Again, please, there's nothing that I can do about it. So you may need to turn up your volume. YouTube changed their format. It's a whole thing. Let me just see if this will even come full screen right now. Hello. And we're breaking the internet. The YouTube. Why are they showing me the chat? My second screen does not show the chat. Hold on. Hello. What's this? All right. So it sounds like the attorneys called for this conference because she kind of says at the beginning, "What are we doing here?" And I don't know that any outlet has a better feed than this. So this is the feed we're going to have to deal with. If you have to turn up your volume on your end, just it is what it is. I don't have fancy equipment, modulation, sound booster on my browser isn't working right. I don't know. But here's what happened about, I think, a little around 10 a.m. maybe, a little after. So let me know that you can hear it at all. The volume's not up yet.
What is back to session? You may be seated.
22117.
All right, so why are we out here?
Your Honor, I just saw the verdict forms, and as we discussed yesterday, the amendments that the court indicated it would make them.
Oh, no. Okay, I did not say I'd make it. I said I'd think about it. I said I was.
Okay, so he said, Your Honor, I just saw the verdict forms, and as we discussed yesterday, you were going to make a change to it. And she stops him and says, oh, no. That's not what I said. I said I was tired and I would think about it. So I'm going to play that again for you so you have an idea of what he's saying and the way she responds to him. And then she goes off on Karen, so just pay attention.
What is back to session? You may be seated.
22117.
All right, so why are we out here?
Your Honor, I just saw the verdict forms, and as we discussed yesterday, the amendments that the court indicated it would make them.
Oh, no. Okay, I did not say I'd make it. I said I'd think about it. I said I was tired and I needed to think about it.
Before you were tired and you needed to think about it, was you agree that there needs to be not guilty options for the subordinate charges?
No.
Okay. And he said, you said you were tired, but you agreed there needed to be not guilty options for the subordinate charges, which are the lesser includeds
under count two.
I said
under count two.
that it made sense to me, but no, I did not change it upon looking at it because the verdict slip, this verdict slip as submitted to the jury is exactly how it always is in Massachusetts.
I asked the question. I don't really care how it always is in Massachusetts. I care about whether or not it's appropriate.
It's appropriate.
Different thing.
Did you hear what AJ said? He said, I don't really care whether it's the way that it's always done in Massachusetts. I don't think it's appropriate.
It's appropriate.
Let me make my argument, if you wouldn't mind, Judge, why it's not appropriate. For a superior charge, they have to decide that she is not guilty of the superior charge. And that is the starting point of whether or not she is guilty or not guilty of any subordinate charge, often called a lesser included. Once they decide that she's not guilty of the superior charge, now there's two additional charges that they've been instructed they must decide whether she's guilty or not guilty of. How do they decide that she's not guilty of the first subordinate charge, involuntary manslaughter?
Okay. Anything else you want to say, Mr. Jackson?
I'd like an answer from the court. How do they decide that she's not guilty of involuntary manslaughter on that verdict?
That's their decision to make.
And how do they make it if they don't have an option to check a box that says not guilty?
They don't check the box that says guilty, do they? And then when they go to the next block, they don't check the block that says guilty, and on the top you're left with not guilty. Okay?
So it's the absence of the check mark that the court determines is the not guilty finding by the jury.
Yes, that's what the verdict slip reads. It reads not guilty. If they don't check block 2, 3, or 4, the verdict slip reads not guilty. Okay? That's how it is, Mr. Jackson.
Well, and apparently that's how it's going to be because of the court's order. That is not how it should be, and it's over our strong objection. They need to see that there is a not guilty option for the subordinate charges. If they come back guilty on, for instance, involuntary manslaughter, that's immediately appealable. They didn't have an option on the verdict form to find her not guilty. It's almost like the court is directing a verdict of the subordinate charges.
Okay. I disagree with you. Mr. Yannetti, you've seen verdict slips exactly like this. Okay?
I actually haven't really.
She says, Mr. Yannetti, you've seen verdict slips exactly like this. Because he's from Massachusetts and Alan Jackson is from LA. And he says, actually, Your Honor, I haven't.
Have you had no lesser includeds?
No, we've always had lesser included, but I have not seen a verdict slip there where not guilty is not an option. For
Okay. I just
She chuckles and says, have you never had any cases with lesser includeds? And he says, well, yes, I have, but there's always a not guilty option.
disagree with you.
And
All right.
I don't see the
Excuse me. This is funny, Ms. Reed. All right, we're done.
All rise for the court, please.
Did you hear that? This is funny, Ms. Reed. That's a great thing to say from the bench on worldwide television, isn't it? I'm going to replay that one more time. We're going to hear that whole entire thing one more time without me interrupting so that you can get a full picture of what happened a little while ago. And then if you have questions, well, I will explain it first. And then if you have further questions, we will go over them.
What is back in session? You may be seated.
22117.
All right, so why are we out here?
Your Honor, I just saw the verdict forms, and as we discussed yesterday, the amendments that the court indicated it would make.
Oh, no. Okay, I did not say I'd make it. I said I'd think about it. I said I was tired and I needed to think about it.
What you said before you retired and you needed to think about it was you agreed that there needs to be not guilty options for the subordinate charges under count 2.
I said that it made sense to me, but no, I did not change it upon looking at it because the verdict slip, this verdict slip as submitted to the jury is exactly how it always is in Massachusetts.
I asked you a question then. I don't really care how it always is in Massachusetts. I care about whether or not it's appropriate.
It's appropriate.
Different things.
It's appropriate.
Let me make my argument, if you wouldn't mind, Judge, why it's not appropriate. For a superior charge, they have to decide that she is not guilty of the superior charge. And that is the starting point of whether or not she is guilty or not guilty of any subordinate charge, often called a lesser included. once they decide that she's not guilty of the superior charge, now there's two additional charges that they've been instructed they must decide whether she's guilty or not guilty of. How do they decide that she's not guilty of the first subordinate charge, involuntary manslaughter?
Okay. Anything else you want to say, Mr.
She's like,
Jackson?
okay.
I'd like an answer from the court. How do they decide that she's not guilty of involuntary manslaughter on that verdict?
That's their decision to make.
And how do they make it if they don't have an option to check a box that says not guilty?
They don't check the box that says guilty, do they? And then when they go to the next block, they don't check the block that says guilty. And on the top, you're left with not guilty. Okay?
So it's the absence of the check mark that the court determines is the not guilty finding by the jury.
Yes, that's what the verdict
Pretty
slip
much.
reads. It reads not guilty. If they don't check block 2, 3, or 4, the verdict slip reads not guilty. Okay? That's how it is, Mr. Jackson.
Well, and apparently that's how it's going to be because of the court's order. That is not how it should be, and it's over our strong objection. They need to see that there is a not guilty option for the subordinate charges. If they come back guilty on, for instance, involuntary manslaughter, that's immediately appealable. They didn't have an option on the verdict form to find her not guilty. It's almost like the court is directing a verdict of the subordinate charges.
Okay. I disagree with you. Mr. Yannetti, you've seen verdict slips exactly like this. Okay?
I actually haven't run.
Have you had no lesser included?
No, with oversight, lesser included, but I have not seen a verdict slip there where not guilty is not an option for the rest.
Okay. I disagree with you. All right.
And I don't see the
Excuse me. This is funny, Ms. Reed. All right. We're done.
All rise for the court, please.
So dismissive. Like what? Think this is funny, Ms. Reed? Is this funny? Something funny, Ms. Reed? What say you, my friends? What say you? I was trying to get a copy of the verdict slip so that we could look at it together, but I can't get it. I don't think it was filed in the public filings, and I don't see it. But those of you who have served on jury duty know that you get a verdict sheet. I call it a verdict sheet. They call it a verdict slip when you go in to deliberate, and it's a list of things that you need to find and check off boxes, right? So the superior charge, as they called it during that conference, is the second-degree murder charge. And for that charge, AJ said that there is a guilty, not guilty version, guilty and not guilty box for them to check with regard to second-degree murder. The next charges after that are the lesser included charges. So if they find not guilty on the second-degree murder charge, then they move on to the next charge, which is manslaughter while operating under the influence, right? We went over these yesterday, but I'm going to do it again because it looks like we have a lot of new people here. Oh, it's posted. Okay. All right. Let me see if I can find it. So the lesser included charge, well, maybe it'd be easier if we have a copy of it before we talk about it, and that'll be easier to see. All right. Hang on one second. Oh, look at that. I have the verdict slipped. Okay. Look at that. Thanks to somebody sending it to me. Thank you, Megan. Oh, you guys are so awesome. All right, let's take a look. See how this is such a collaborative channel? You guys are really amazing. All right. I had an article that I was going to read to you from today's Boston Herald, which we can get to after this. And so here it is. This is what a verdict slip looks like. I call it a verdict sheet. Commonwealth versus Karen Reed. This is something that goes back into the jury room with the jury. And here's the first thing that they need to decide. Manslaughter while operating a motor vehicle under, well, that's the manslaughter charge. Where's the murder charge? I feel like this is. I feel like there should be another sheet to this. Manslaughter, well, I thought it was second-degree murder. This doesn't even make any sense to me. In the above entitled case, we, the jury, say that the defendant is not guilty or guilty of offenses charged manslaughter while operating a motor vehicle under the influence. Check one or both of the following: manslaughter while operating a motor vehicle under the influence of alcohol, manslaughter while operating a motor vehicle with blood alcohol level of 0.08% or greater. Number 3, guilty of lesser included offense of involuntary manslaughter. Number 4, guilty of lesser included charge of motor vehicle homicide, felony OUI, liquor and negligence. Check one or both of the following: motor vehicle homicide by operating a motor vehicle under the influence of alcohol, and or motor vehicle homicide by operating a motor vehicle with blood alcohol level of 0.08% or greater. If I'm an attorney and I don't understand this verdict slip, how is a jury going to understand this verdict slip? Huh? It's whack. There's no way for them to check not guilty on any of these additional charges, which is what he's arguing, and there should be. That's not the final draft. You're right. I don't think this is the final draft. Well, let me take this down for a second because I don't know that this is the final draft. Let me see if I can find it. Did somebody say that Ted Daniel posted it? Let us see, shall we? He's got the same one. Yeah, right. It's 2 pages, right? Hold on. That's not the page. It's missing. Check one of the following on the actual. Yeah, it's. That is the final draft, but it's 2 pages, not 1 page. Somebody says. So I don't know why the one that I have in front of me is 1 page, and I cannot confirm or verify that this is the exact real one. So I hesitate to even opine on it other than to say that what we just saw in court is actually what did happen in court about half an hour ago, and that's what they're arguing about. And he finds it very confusing for the jury. I find it very confusing as an attorney. And there should always be a not guilty box for them to check. Otherwise, they think they have to check a guilty box. And that is exactly the point. And she says, that's the way we do it here in Massachusetts. So tough luck. And he says, well, that's an appealable issue. And so that is ridiculous. All right, here's the standard verdict form. Thank you, Suzanne. Pull this up so we can see the difference. Although I'm not equipped right now to do these side by side at this exact moment. Here's the standard Massachusetts verdict form. Although it seems nothing is standard in Massachusetts. Oh, stop. Oh, stop. How can I do this better? All right, so this is the typical one. It says Commonwealth of Massachusetts jury verdict form. Come on, man. Come on, man. We, the jury, unanimously return the following verdict. Check only one of the four choices. All right, stop. We find the defendant not guilty of the offense of operating motor vehicle. Okay, so the top box should say, we find the defendant not guilty of the offense charge or any lesser included offense. Looks like it's the standard jury form. Thank you, Suzanne, for sending this to me. Option number 2, we find the defendant guilty as charged of the offense of, like, they would fill this in with the actual offenses. Operating a motor vehicle on a way or in a place where the public has a right of access. So they need to have a not guilty box, he's saying, for not only the superior charge, the murder and the second degree charge, but for every other lesser included offenses. And that first option here in this form would be a catch-all. We find the defendant not guilty of the original offense charge or any lesser included offense. And she does not have that on her verdict form, which is very strange. Oh, thank you for page 1. And then on this form, this looks like a Blumberg, what they call Blumberg form. So in this standard form, it says we find the defendant not guilty of the offense charge or any lesser included. And then you have the options. We find that he or she guilty of this one, that one, or the other one only. Right? So that's the way the standard form looks. And somebody just sent me the first page of the form that we were shown, which says, that's not it. All right, so here's page 1. Of what the actual jury has. Let's go here. All right, so this is page 1. Commonwealth versus Karen Reed verdict slip. And here's the first charge, murder in the second degree. In the above entitled case, we, the jury, say the defendant is not guilty or guilty of the offense as charged, murder in the second degree. So this is the first portion of the verdict slip. That's page 1. Here's page 2. And this is the first of the lesser included, or the second charge, manslaughter. So that she's charged with murder in the second degree and also manslaughter while operating a motor vehicle under the influence, which is this second page. So they need to, if they find not guilty on the first one, then they go on to this one. And this one says manslaughter while operating a motor vehicle under the influence. And then they say not guilty, or guilty of manslaughter while operating a motor vehicle under the influence. And in a separate handout, they've got all the elements that they need to go through for each charge. And then it says, number 3, guilty of a lesser included offense, involuntary manslaughter, but it doesn't say not guilty of a lesser included offense, involuntary manslaughter. You see what he's saying? And it should say also not guilty for that. And then it says guilty of the lesser included charge of motor vehicle homicide, felony OUI, liquor. And that's the one that includes negligence. Number 3 includes intent. We went over that, and she went over that in the jury instructions. Charge 4, as it's written on this second page of the verdict slip, is motor vehicle homicide with negligence, but there's only an option for guilty. There's no option for not guilty. And what the judge is saying is, well, if they just don't click guilty, then it's not guilty. You see what I'm saying? And it is very confusing. It's very confusing for me as a lawyer. It is very confusing for lay people who are the jurors in this case. And I think he's 100% right. And I think she was very dismissive. And I think that she was very condescending. And I think that just because that's the way it's always been, and we talked about this last night, Mark Betterow and I, just because it's the way it's always been doesn't mean that it's the way it should be done now, today, here, in this case. It looks like there may be a third page. Thank you to Oblivious Benson. Okay, and then there's a third page. Thank you, OB. And here's the, oops, boop. Here's the third page. And this is the third official charge, leaving the scene of an accident resulting in death. And then they have an option for not guilty or guilty. See? But when you go back here to these lesser includeds, there's no option for not guilty. There's only an option for not guilty of manslaughter while operating under the influence. It's very confusing, and it doesn't give them a lot of options. And how the hell are they going to be able to figure this out? All it's going to do is delay things. Well, no wonder they didn't come back yesterday. You know, everybody was so confused about why they didn't come back yesterday. No wonder. Take one look at the verdict sheet. First of all, they have to go through all of the jury instructions, which are probably thick. And then they've got to get to this. And then, of course, they're going to be confused. Unless they do a straw poll, which she told them they shouldn't do, which she's not supposed to say that they shouldn't do that. And a straw poll is basically where everybody just writes guilty or not guilty on a little piece of paper. They throw it in the middle. They read them all out. Guilty, not guilty. You've seen it a million times on TV and in movies. And that's the way it's done. And that's not the way they're doing it here. And Alan Jackson is pissed, and rightfully so. Rightfully so. This is the wild, wild Commonwealth of Massachusetts. And they're just like, this is the way we've always done it. This is the way we're going to do it. Too bad. And remember, because we covered all the pretrial motions together, and the defense made a motion to switch courtrooms because the original courtroom that they were in, which was a much bigger courtroom, required at least 3 or 4 members of the jury to sit behind the witness and only see the back of the witness's head. And like the judge literally said during oral argument, this is the way it's been done for 100 years. And we talked about it together. And I said to you, I think it's very important that the jury needs to see the witness's face. How could you judge credibility without seeing a witness's face? And I think it was even brought up like, well, they can read their body language and they can, they can see their posture and they can base their credibility on that. What? That's insane. And could you imagine the jury not being allowed to see Jen McCabe's face during her testimony or anybody else's face during their testimony, like, Proctor, Albert. What say you? After we talk about this a little bit, then we're going to go back and read this article from the Herald today, Reed Case, Theater of the Absurd by Howie Carr. And yesterday, Sean McDonough was on Howie Carr, I believe. So, WTAF, maybe WTAF today. I can even make that louder. I don't curse on this channel, and you guys know that because you appreciate it when your kids are in the room and you're at work and you have no headphones on and you want to listen. But really? Really, Norfolk County? Really? Is this the way you want the world to watch what's going on in this case? This case has garnered worldwide attention because Karen Reed could be any one of us. And the defense theory is that Karen Reed was framed by a corrupt system and a corrupt organization known as the Massachusetts State Police and the Canton PD. So much so that the FBI had to get involved and run a parallel investigation into this investigation of the Karen Reed murder because so many things were mishandled and perhaps planted, and maybe even Karen Reed was framed. And I think that there are many of us who have watched this entire trial. We have also, on my channel, been through all the pre-trial motions, all the pre-trial hearings, all the documents, all the police reports, all the witness statements, every single document we could get our hands on. And there is so much improper, mind-blowing things going on here that point to the fact, very simply, and I've said this since day one, Karen Reed did not hit John O'Keefe with her car, and John O'Keefe was not hit by a car. And that is what we heard two PhD trained accident reconstructionists tell us on the stand, and they were hired by the FBI. Physics doesn't lie. Physics doesn't lie. Do you think that Trooper Paul's theory of how this accident allegedly happened, because I do not believe he was hit by a car. I've been handling motor vehicle accidents for over 30 years, hundreds, if not thousands of them. And I've never seen a pedestrian collision, whether they're in reverse or whether they're moving forward. The car, that is, whether the car is hitting a pedestrian moving in a forward direction or backing up into a pedestrian without some sort of lower body injuries. And even Dr. Sheridan, who's a renowned medical examiner, retired now, from San Bernardino County in California, said the only autopsies that he conducted of pedestrians being backed over by motor vehicles were children. And you can bet that those were horrific autopsies to perform. And my guess is because most people who are backed into by a motor vehicle do not die. They don't die because you cannot move a motor vehicle in reverse, despite what the Commonwealth wants you to believe, at 24.2 miles per hour. It's just nearly impossible. So those cases of children were, I'm sure, very tragic, and children are small and they're dragged under the car. And we've all read stories about it, about parents who sometimes horrifically have backed over their own children in the driveway because cars at the time did not have backup cameras on them. So this is insane. This is the way they do it, and we're all just supposed to just deal with it. So the jury went in at 9 o'clock. It is now 11:20 a.m. East Coast time. So they've been in there 2 hours and 20 minutes. They were in for about, they went in at 1:30. They probably took a break for lunch, 2:30. They left by 4. So really an hour and a half yesterday. We don't really know what's going on inside the jury room because we're not supposed to know. And we probably won't know until if and when a juror speaks after their verdict. So They told the attorneys they need to be back in 5 minutes notice when a verdict is reached. It could take days, Michael. We don't know what's going on in there. We don't know. Good morning, Charlie. I've never been in my life so angry at a judge. This judge doesn't think Karen has the right to offer a box to check that says not guilty, as always implying that the only option is despicable. I didn't see her laughing, but the camera was not on her, on Karen, when the judge said something funny, Miss Reed. The world is watching. All right, let's just try and be a little more classy. How about that? You're trying to send a woman to prison for the rest of her life on trumped up murder in the second degree charges without any evidence that he was hit by a car, except for a trooper who took a couple of Zoom classes and thinks he was sideswiped in the arm. The taillight exploded, made perfectly linear abrasions in his arm. He did a pirouette, smacked his head on the curb, maybe. I don't even know what the final theory is yet. And then was flung 30 feet into the yard. And that's what you expect the world and the jury to believe? And you don't hire your own accident reconstruction expert, a professional firm, because why? You couldn't find someone to take the case? You couldn't find someone to agree with that theory? I'm not surprised. BC Scanner says the not guilty checkbox will reveal itself over the next few weeks. That is very funny. So far, comment of the morning. Oh, thanks, Laura. I take a day off so you can enjoy the prom with your girls. Well, I'm here for a little while until we have to go do pictures and stuff. Thanks, Laura. Thanks on top for the super sticker. Nina, what's my opinion on that verdict form? I think it's crap. I think it's very confusing. It's confusing for even me to understand. I'm a very, very experienced trial lawyer. So there's that. I think Alan Jackson is 100% right. And even David Yannetti agreed too. And he is a Massachusetts attorney. He says, I've never seen it. And she gives him she digs him and says, oh, you've never had any cases before with lesser included charges? I mean, I've been trying to give the judge, a break. I'm about at the end of I'm on like my last thread of patience. Can the jury ask about the form during deliberations? Yes, Stacey, they can come out with a question, and they may. They very well may, because they're going to be like, okay, why are you only giving us a guilty option on this and not a not guilty option? It's like everything else in this case. It's just magical. It's just supposed to magically appear and reveal itself, right? And the magical mystery Sallyport, and where videos are inverted, and it's like we're in Wonderland. It's like I called myself Alice. You can see that Alice is sometimes on the top of the screen there because I fell into this rabbit hole of this case, and we're still down here. And there's a Queen of Hearts, and there's a Mad Hatter, and there's a Cheshire Cat, and they're all here. And this ain't no freaking tea party, Judge Canoni. So, what is up with that? Showing us a video that's mirrored where it looks like someone's getting out of the passenger side of the vehicle, but it's really the driver's side. And then your Buchanan tells us, well, yeah, no big whoop. It's just like looking in a mirror. You can still see your face. What? They really tried to get that through until cross. That there was nothing wrong with that video. There is so much rotten in Canton that it's not even funny. And then yesterday they allow, or they permit, or they are okay with the third-party culprits who were actually named in the defense's closing arguments to be sitting right behind the O'Keefe family. Brian Albert and Colin Albert, flanked by, to use one of their own terms, Brian Albert's flanked by Jen McCabe and Kerry Roberts, as if to say, the family doesn't think these people did it. Or as if to say it's okay that they're here staring down the jury, even though they've been painted to be a very influential and or dangerous, perhaps, family in some people's opinion. It's whack. It's whack, and you'll never see anything like this again. And I've never seen anything like this before. It's almost like, the Corleones. Like, Really? Somebody going to find a horse's head in their bed next? Like, what are we? Melissa, thanks for the 5. Curious, can Bev have disciplinary action taken against her, law licensed by the state license board for misconduct if proven? No, they have judicial immunity. So her decisions are her decisions. They're judicial decisions, and they are well within her rights, as she likes to say, unless there's something like a crime involved, which I don't see here. But then they could take some action. But aside from that, I mean, her rulings are her rulings. She's a judge. They have immunity. Kirsten, thanks so much from Canada. Happy 1st anniversary, Melanie. Here's to another year together. You're the light we have all come to love, and I appreciate you so much. Oh, I appreciate you so much, Kirsten. It is 1 year exactly today, I think, since I either did my first live or posted my first video on Kevin Costner. So here we are, 52,000 subscribers later. You guys are amazing. And we've built a community here that doesn't tolerate the bullying, the trash talk, the foul language, and the hate. And we have my moderators and you guys to thank for that. So thank you. Paige, thanks for the 5. It appears it is missing the phrase choice 1 of the 4 below, as other Massachusetts have, that Bev's referring to. Thanks. I think that was earlier because I showed you the standard form. Crypto tax lawyer. Melanie is speechless. Lots of Massachusetts attorneys speaking out. I have it. How to send. Thank you. I got it. We did it. We did the thing. You're a lawyer too, right? Crypto tax lawyer in Massachusetts. And people are outraged. It is day 32 of this trial, and we are still outraged. I do not live in Massachusetts. I do not practice in Massachusetts. I'm in New York. You guys know that. And I've been outraged about this for a long time. Oh, Kurt at Uncivil is very angry. He's that's crazy. He's angry a lot, and good. I'm glad. I'm feeling validated. Thank you. Bruni Saint, thanks for the Australian 10. Welcome to Hello Down Under. Shouldn't the foreman at least be given clarification? Yeah. But I guess she just assumes that they'll come out with a question if they have one. Thanks, Gaelic Magic says, so glad I found this channel to watch this case. I appreciate you. Chantal, I can understand appealable issue, but wouldn't she have to stay in jail for that if found guilty? Depends on if they would remand her or release her pending appeal. I don't know. Let's not go there right now. Right now, she's out on like $80,000 or $100,000 bail for the last year and a half. Go Georgia. Thanks for coming in also from Australia. Bev says she was too tired to do this yesterday. Surely a valid appeal. Can we start an online petition against this judge? No, I would not recommend that. Let's just let it play itself out. BC, thanks. How long before there's integrity from the court? Well, we're all holding our breath for that, right? We've been waiting. Melissa, thanks for the 5. Jury instructions unnecessarily complicated. Deception is complicated. Truth is not. Excellent point. Cynthia, motion to get Auntie Deb in here to help us deal. I don't know where Auntie Deb is today, but I'm on limited time. It's prom day. Joanne, thanks for the 20. Happy 1-year anniversary. Thanks for all you do. Thank you. Thank you so much. Karen, an emergency call needs you to be put into the Attorney General. I don't know who's going to do that, but I'm sure they're watching, Karen. I'm sure they're watching. They've got eyes on this. I'm sure of it. Gen X, thanks to the 5. When will the FBI get involved? Karen Reed, not guilty. I don't know. Mark and I talked about that last night. Go back and watch our stream from last night. Oh, thanks, New Hampshire woman, for being a member for 8 months and for saying happy anniversary. I think we've only had the memberships for like 8 months, and I know you're one of the original OGs. Brent, thanks for the 20. Standard form left over from Salem. If she doesn't dunk, she is in fact a woman with a black pointy hat with green skin. Rosa. That's funny. It's a throwback to the Salem witch trials if you're not picking up what he's laying down. Caroline, dear Melanie, happy birthday to an amazing channel. Thank you. Thank you so much, Caroline. Wearmouth. Hello from the UK. Hello to the UK. Hello to my friends across the pond. Sorry, Judge Bev has contributed to this trial, sending into a farce. She cannot hide her contempt for Karen and her lawyers. Yeah, it's coming out. Seems to be coming out. Thanks, Gwen, for your super sticker. Amy Z, thanks for the 10. Andrea B says on X is if jury acquits on greater but hangs on lesser, there's no way to indicate that, and double jeopardy bars retrial. on any acquitted offense. All right. Well, let's see if I can pull up what she is saying so that we can take a look at it. So here's what Andrea Burkhart says. She's another law tuber. She's been around for a while. She's an OG. She is an appellate attorney, I believe, by trade. Andrea Burkhart says, my concern with this verdict slip is if the jury acquits on a greater but hangs on a lesser, there's no way to indicate that. Double jeopardy bars retrial on any acquitted offenses. What's the harm in giving them clear options for each charge? Don't understand the ruling at all. Thank you. I feel validated because I didn't look up anybody's opinion. What I did was I texted Mark Betterow and I said, I know you're on trial and I know you don't know what's happening, but here's what's happening. What do you think? And he says, ridiculous. She should at least advise the jury that not guilty box applies to all charges and that each must be considered. And so there you go. There's that. Thank you, Amy, for pointing that out. Rob says there may be people on the jury with extremely smooth brains. I don't know. I don't know, you guys. Every day is a new day here. It's like Groundhog Day. It's like the Twilight Zone. It's like our playlist. I wish I could play some music for you but I can't because YouTube definitely hates music strikes. They will strike you for music. Auntie Bev's verdict form, aka Kirsten. I love it when you guys change your names to match the trial. Thanks, Kirsten. I am outraged. Because if you're watching this channel, you know what we've been talking about. And if you haven't been watching this channel, it's not a neutral channel. My name is Melanie Little, and I am not a cupcake. That's what that sign says right behind me, that pink sign. You can't read it. It says, you can't make everyone happy. You're not a cupcake. I have 5 kids, and nobody is always happy at the same time. I can't make everybody happy. I just can't. So just because I'm a lawyer doesn't mean I have a neutral channel. Sometimes I'm for the plaintiff. Sometimes I'm for the defendant. Sometimes I'm for the prosecution. Sometimes I'm for the defense. But what I always am for is the Constitution, the rule of law, procedure, and justice. So my opinions shift with each case, but I'm not going to sit here and just be a neutral arbiter of reading documents to you. How boring is that? If you're here because you want my opinion. And if you don't, well, then there's plenty of places that you can go watch coverage with artificial intelligence robot voices reading to you over a montage of photos. I mean, that's your choice. Ryan Blackhawk, thanks. I just strained my eyes from rolling them so hard at the judge's BS. This implies the court thinks Karen Read is guilty. How could any jurist listening to the circus of evidence that we have witnessed during this trial think that there's any evidence that John O'Keefe was hit by a car? And if you don't get past the John O'Keefe was hit by a car, you can't convict on any of the charges. So if I'm the foreperson of this jury, as an attorney, right, I'm going to go around the table and say, okay, first let's vote on whether we think he was hit by a car. Because that is a necessary thing for them to find in order to find her guilty of any of the charges. You know what I'm saying? So if nobody believes that she got hit by a car, it's game over. Not guilty on everything. Oh, thanks, Melly. Happy 1 year on YouTube, Queen. Thank you. I'm just a girl in the world. Thanks to the 5. That verdict slip might as well be written in Chinese. Yeah, nobody's going to understand it. Chef's Pawn, thanks for the 10. Karen Read should be put in the next Fast and Furious movie if she can drive a can backwards at that speed and pull off a 3-point turn. Yeah. And I mean, we noticed the Commonwealth's version of the events kept changing and changing and changing. In the opening, Lally said the accident happened, or the incident, or the murder happened at 12:45 a.m. Throughout the course of the trial, he changed his timeline, and all of a sudden, during closing, it happened at 12:30 a.m. which according to his own ridiculous timeline, which by the way, didn't even include the fact that Karen hit John with her car on his timeline. Why is Jen McCabe saying, here, pull up behind me at something like 12:40? She's still looking out the window. None of it makes sense. Make it make sense. Marcelo, thank you so much for your super chat. The disdain Bev has for Jackson because he's not an attorney in Massachusetts is like, we do it like this here. Leave it if you don't like it. Oh, Marcello, I'll call you Marcello. We have been seeing this throughout the course of the pretrial hearings. If you didn't watch them, I've got an entire playlist. I think we're up to 70 something videos on this. And it's been going on the entire time. She once said to him, it's a privilege for you to be admitted pro hoc vice in Massachusetts. It's a privilege for you to be in this courtroom. And a lot of, this is the way we do it here in Massachusetts. It's been going on for a long time. Tina, thanks for jumping in from Canada. My daughter's dog jumped on me with muddy paws. It left marks on my pants. I was like, holy as those are the same. Never second guessed it, but seeing it was so weird. Yes. Tina, yes. And BB2, thanks for the 20. And BB2 was my first member ever. And you will go down in history as being my first member ever. Congratulations on your first year with us. I'm so glad I found you first on Police Off the Cuff and then Duty Ron. This is only the beginning. You're going to receive that silver reward for 100,000 very soon. Love you. Oh, that'd be so awesome. If everyone who's here, there's 10,000 of you here, 10,059. And I love every single one of you. And if you would hit that subscribe button below, it's free. It's totally free. It helps the channel. Yeah, I want that silver plaque. Thank you, Aunt BB. Thank you for always being there to cheer me on. Scarlett Rose became a new member. Welcome, Scarlett. Persephone's pomegranate. Thank you for popping in to say happy anniversary from Canada. I mean, what a crazy ride that if the verdict happens today, it will be on my exact 1-year anniversary of starting this channel. That's insane. Wine Yogi, thanks for becoming a member because I've been so passionate about this case. And I have no personal connection to any of the players in this case, unlike Trooper Proctor and, Trooper Buchanan and, Sergeant Good, Gallagher, and everybody else who lives in the neighborhood. Gringa, thanks. Thank you for all you've done and enjoy prom day. Thank you. The Reed family is very upset, says Suzanne. If there's any guilty verdict, there will be an immediate appeal. Thanks. I don't know how you know that, but I know that you have boots on the ground somewhere near there, maybe some connections. I don't know, but thank you. Wendy Darling. Wendy Darling. Isn't that a Peter Pan reference? Thanks for 20. I've lived in Massachusetts for over 50 years, so I shouldn't be surprised. The judge sounds like a mean teacher berating a teen, right? I felt that way too, like a principal, like you're brought into the principal's office and you have to get in trouble for something that you did. Love your commentary. Shout out to my dog, Bella. She watches Taylor with you. Hey, Bella. Hey, Bella. What up, girl? People say that when I sing the Lollipop song that their kids sing along with me. Oh my gosh, that's so funny because Andrew says I have that Lollipop song stuck in my head and I hold you responsible. Sorry, Andrew. Sorry. Every time he would flop, we would sing Lollipop, Lollipop. And then the children at home would sing along and it became a whole sing-along thing. Teresa, thanks for popping in from Canada. I believe John was assaulted shortly after he entered the home. Had Karen gone into the house instead of driving away, she may not have come out alive because she could have been a witness to his assault and murder. That is an interesting thought. Thank you, Teresa. Sharon is rage crocheting and she loves us. We love you too. We have a rage crochet club here. Sharon, I think, is the president. She's created some beautiful things. Please hit the like button. Love you, Melanie. Love you too, Mystique. Thank you. We still have a fan up. I've got the feed up. So if anything happens, we'll be here to hear about it. Gringa, someone in a fight for her freedom is allowed some nervous laughter at this moment. Shame on the judge for that reprimand. Yeah, because, the deck's been stacked against her since she was first charged in this case, since Proctor got on the stand and told you and the world and the jury that he decided within 16 hours when he was texting with his elementary school and middle school buddies, she was guilty. They're going to pin it on the girl. And that Brian Albert wasn't going to catch any flack, I'll call it, because he's a Boston cop too. When his friend said, oh, I guess the homeowner's going to catch a lot of flack, Michael Proctor said, nope, he's a Boston cop too. Thanks, Maureen, for your super sticker. Thanks, Anne, for being a member for 8 months. Another original OG. Happy birthday, happy anniversary, Melanie. Always amazing. Thank you. Thank you, Bodine62. Thanks for the 10. I was worried about a fix the whole time. I've tried to remain positive, but why should this verdict be any less corrupted than the entire case? I feel sick. I think you're in good company here. Amanda says, happy 1 year. You and your channel are absolutely fabulous. Free Karen Reed. Thank you, Amanda. You're an amazing part of the channel. Sandra, this is so crazy. Really? Can you hear us shouting from Singapore? Yeah, I can actually. Thank you, Sandra. Mofo, what could they possibly be deliberating? The reasonable doubt is off the charts. I agree. But it takes a long time to get through the jury instructions. It takes a long time to read all the charges, go through all the elements. Maybe they're confused. Maybe they'll come out with a question. It's so hard to know what's going on in there. And look, a woman is facing life in prison. They're not just going to rush through it. I did think it would be here yesterday, the verdict, but I still think there's enough reasonable doubt to drive a Franken truck through. How do you like that? And we were very lucky that Lucky came in and testified. Well, thanks all about the shade for being a member for 7 months and for saying happy anniversary. Hope your babies enjoy their prom. Thank you so much. Donna, Canton's not the only town with such corruption. That's true. It's true, Donna. Oh, thanks, Kathy, for saying happy anniversary. It's not about me today, though, you guys. It's just not about me. KM Karma Matters, Justice for Officer John O'Keefe. Thank you for coming in from Canada. Imagine how the jurors would feel if they convict Karen on something because they misunderstood the form. Bev is infuriating. Yep. We've been infuriated for a very, very, very long time. If you know, you know. Michael Martin, thank you. I can't rule out the McAlberts getting to one of the jurors and we end up hung and have to do this all over again. Michael Marcy will definitely recharge her. When is he up for re-election? Does anybody know? Yeah, Michael Proctor was right. Somebody said in the chat, it's moving so quickly. But something like, I can't find it, but that's another thing that he said. I wish she would just off herself. When is his term up? He's elected and he's run unopposed for many times. And I believe that he was he's been the DA there since like 2010 or something, right? Christine became a member. Welcome. Suzanne sent me the verdict slips from the Chesna trial, which Auntie Bev presided. Thank you, Suzanne. I will take a look at that when I have a spare moment. Ryan, can a not guilty verdict be appealed by the state? Nope. Nope. Put some nope emojis in the chat, members. We have special emojis just for this trial. Oh, the jury has another question? Well, we've got Boston 10 up. So we'll see. We'll put that back on. They come back with the question. Thank you, Kirsten, for that. Or Kristen, I couldn't see. My eyes are blurry, and I've been at this for days with you, and I'm exhausted. But no, they cannot appeal a not guilty verdict. That is it. Double jeopardy has attached. The defendant can appeal a guilty verdict, but not the other way around. Whack job. Silver lining of seeing them manipulate this jury is that it suggests that the jury itself is not rigged. Karen has a chance. I don't think that played well for them to have them show up in court like that. I think it could have like the reverse effect. G. Peter Grant, thanks for the 10. Great coverage and commentary. Learned a lot from you during this case. Can't believe this case is actually still going on. I spent 5 years as a Canton firefighter. I can't imagine being there for this. Thank you for your service as a firefighter and for your comment. And I guess that you are on the side of justice here and that you believe that something nefarious is and was at play. Thank you so much for your service. Julia, thanks for being a member for 2 months. Today can be about multiple people. Happy anniversary. Thank you. Thank you. A Grammar Police, not affiliated with the MSP. That's great. I love it. I'm the Grammar Police too. Also, lesser is misspelled on the form. It is. I hate misspellings. I didn't see it, but I'm surprised it didn't stick out to me like a sore thumb. Flowoski, thank you for your super chat. I might be showing my age, but did anyone else get accountant from Ghostbusters vibes from Lally? That actor is Louis Tully, as a reminder. That's funny. Thanks, D24, for a happy 1 year. And Sarah for becoming a member. And Elle says, happy 1 year, well deserved. Cupcake, other channels speak highly of you. Love your honesty and compassion. You knew Karen Reed was innocent from the beginning. Bless. Oh, thanks, Elle. Thanks, Elle. You're always here, always participating. Oh, and look at Lori, Life 360 for the win, who's so amazingly generous every single stream. Gifted 10 memberships. Thank you. Thank you, Lori. And to those of you who got them randomly, welcome. All right. Well, it looks like the camera's moving a little bit on Boston 10. So maybe he's getting ready to pan down. I don't know. Thanks, Lori. Disabled Rebel, thank you. This verdict feels like a final nail waiting to seal the coffin of justice, of Lady Justice. Hopefully the jury gives us hope that justice still lives. Yeah, I agree. They're moving it. The fan's moving. I mean, the fan is moving, the camera's moving. But now the fan just stopped. What is going on? It like froze up on Boston 10. Every day is an adventure over here in YouTube and StreamYard and all the things that make me crazy. Probably questioning the form. You think people they're gonna censor it? Because like it like literally Boston 10's feed on YouTube just froze up. Thanks, Karina, for being a member. John and I have loved your coverage, Mel. Thank you. Thank you, Karina, and hi to John. The jury has a question. Jury has a question, but I don't know why Boston 10's feed just literally froze up. See if Court TV's got a feed up. Let us see. No, they've just still got a picture of Karen. Oh, I think there's a, they're showing a commercial, I think, on Boston 10's YouTube. And we wait. Hi, Susie B. New to your chat and enjoying it. Is it the norm for a judge to handpick the foreperson? In New York, whoever is seated as juror number 1 is automatically the foreperson. That's just the way it's done. I don't know what goes on in Massachusetts, but she did pick the juror who was in seat number 1. So I can't say. I can't say. It's just the way it's done in New York. And in New York, you go into a trial knowing that you're the alternate. Here, they pick the alternates at the end, but she picked the foreperson first and then they picked the alternates out of a rolling like bingo thing, almost like a lotto thing, where they pull the numbers out of the bin, sort of like bingo. Core TV says there's a question. Okay, so we've got Boston 10 up. We're hoping they're going to come back with it live. Hope that answered your question, Susie B. Matisse Yaya, 2026 for Marcy. He's in office until 2026. Good luck. Good luck, you guys. This is why it's so important to vote in these local elections. Everybody thinks, oh, no big whoop. Just voting for judges and, DAs and things like that. But they are very important. Grammar Police more than once, lesser Lessor. No, I do believe that's the legal spelling, Grammar Police. I do believe it is. Oh, they're back.
The confusion this might cause the jury. I think it's easily clarified with the supplemental instruction. I don't think it's the verdict slip. I think it's how they're to follow the verdict slip. So what I've written up, this is a very rough draft. I'll read it to you. I'll take a break and let you consider it if you want. And this works out. I received this, I don't know, 15 minutes ago, and I've been the letter, the question from the jury.
Oh,
So it seems a good time. So I was working on this. It seems a good time to bring them in for an answer to that question. And I would say, as long as I have you here, I want to clarify my instructions regarding your verdict as to count 2 of the indictment. As I instructed you yesterday, there are 2 lesser offenses of that crime, which are involuntary manslaughter and motor vehicle homicide, felony, OUI, liquor, and negligence. Therefore, count 2 encompasses 3 separate charges, the most serious of which is manslaughter while operating a motor vehicle under the influence of liquor. In considering count 2, you should first focus on the crime of manslaughter while operating a motor vehicle under the influence of liquor. And if the Commonwealth has failed to prove that crime beyond a reasonable doubt, then you are to consider the remaining lesser included offenses in descending order. The lead charge is manslaughter while operating a motor vehicle under the influence of liquor. If you find that the Commonwealth has proved all 5 elements or proven all 5 elements of this charge beyond a reasonable doubt, then your verdict shall be guilty of manslaughter while operating a motor vehicle under the influence of liquor. If, however, you find that the Commonwealth has not proven all 5 elements of manslaughter while operating a motor vehicle under the influence of liquor, then you are to consider whether the Commonwealth has proven beyond a reasonable doubt the 3 elements of the lesser included offense of involuntary manslaughter. If the Commonwealth has proven the 3 elements of involuntary manslaughter, then your verdict shall be guilty on the lesser included offense of involuntary manslaughter. If, however, you find the Commonwealth has failed to prove beyond a reasonable doubt the crime of manslaughter while operating a motor vehicle under the influence of liquor and the lesser included offense of involuntary manslaughter, then you are to consider whether the Commonwealth has proven beyond a reasonable doubt the 5 elements of motor vehicle homicide, felony, OUI, liquor, and negligence. If the Commonwealth has proven beyond a reasonable doubt the 5 elements of motor vehicle homicide, then your verdict shall be guilty of the lesser included offense of motor vehicle homicide, OUI, liquor, and negligence. If, however, the Commonwealth has failed to prove beyond a reasonable doubt all elements of manslaughter while operating a motor vehicle under the influence of liquor, and has failed to prove all of the elements of the lesser included offenses of involuntary manslaughter or motor vehicle homicide, felony, OUI, liquor, and negligence, then your verdict must be not guilty to count 2.
May I have just a moment?
Yes.
Is that she either went back into chambers and looked at Twitter, or she had a phone call with someone, or she came to her senses and has decided to reconsider Alan Jackson's argument about the verdict slip being
Thank you, Your Honor, may I be heard?
Yes.
unclear.
I deeply appreciate the court's additional clarifying language. I would simply ask for one very simple amendment, and that is at the top of the verdict slip that says the 2 words, not guilty. We would ask that the verdict slip read, not guilty of the offense charged or any lesser included offense. That's it. And I think that and the court's clarifying instruction would satisfy the defense. Not I think, I know it would. That's all we ask.
All right.
Agreed.
I can repeat that if the court wishes.
So there are some like minor changes we have to make to the verdict slip anyway. Just, the It has to be consistent. So the manslaughter while operating a motor vehicle under the influence, the tab needs to, actually, Tori. So there needs to be some physical changes on the verdict slip. Anyway, it needs to be indented. There needs to be a colon after guilty of offense charged. It's not complete. It doesn't have under the influence of liquor. It just says under the influence. So there are some minor changes that need to be made to the verdict slip. Does the Commonwealth oppose the suggestion made by Mr. Jackson, which seems like a reasonable one?
No, Your Honor.
All right, so it will be not guilty. So tell me again how you want it.
Sure.
You want-
Not guilty of the offense charged or any lesser included offense.
All right, I think the clarifying language that I proposed
He's right, by the way.
is important.
I do too, and I appreciate that. I think with that amendment to the slip and the clarifying language, I think coupling those up is exactly what the defense was asking for. I appreciate that.
So I need to clean, I'd like to send in a written copy of what I just read there. I have a couple of things bolded. I need to fix this up a little bit. I mean, it was just done quickly. The jury's been waiting. Why don't we bring them in? And I will tell them that a new verdict slip will come into them. How's that?
I have a feeling
I
they're,
do, though, have to make a finding that the verdict slip as is was proper. All right, so we'll just leave it at that. I'll make the amendment that you want, but that's my finding.
Thank you, Your Honor. Just from a logistics standpoint, once the new verdict slip is prepared and ready,
We all need to see it.
I was just gonna ask, do we have that emailed to us or something?
Yeah, we all need to see it. I will work with Tori. All right. All right, can we bring the jurors in, please? Oh, I'm sorry. What suggested language on the cert report?
I'm sorry, Judge.
Any suggested language on their question?
No, I think the court's correct, that in terms of the cert report request, the court's answer is right on point, which is you are directed to you're directed to review the evidence that's in front of you, and that's it.
I'm just going to say you have all the evidence in this case. We will not give you anything.
it sounds like the jury's asking for
Okay.
a cert report. But we're going to hear the jury question, but it sounds like the attorneys know what the jury question is. Stop zooming in on their privileged conversations, or you're going to lose the privilege to broadcast this trial. You guys, it's already happened to you once for showing a juror. Didn't you learn the first time? Sometimes I feel like I'm a teacher or a high school principal. CERT is S-E-R-T, the Special Emergency Response Team, I believe, for the Massachusetts State Police. I believe they're the crime scene investigators for MSP, you guys, CERT, S-E-R-T.
All right, so jurors, we're in receipt of your question. Can we request the cert report detailing the search performed? I take this as a request, and the answer is that you folks, you have all the evidence in the case. So what you have is the evidence in the case. You won't be receiving any additional evidence. But as long as I have you here, I want to clarify my instructions regarding your verdict as to count 2 of the indictment. As I instructed you yesterday, there are 2 lesser offenses of that crime, which are involuntary manslaughter and motor vehicle homicide, felony OUI, liquor, and negligence. Therefore, count 2 encompasses 3 separate charges, the most serious of which is manslaughter while operating a motor vehicle under the influence of liquor. In considering count 2, you should first focus on the crime of manslaughter while operating a motor vehicle under the influence of liquor. And if the Commonwealth has failed to prove that crime beyond a reasonable doubt, then you are to consider the remaining lesser included offenses in descending order. So the lead charge is manslaughter while operating a motor vehicle under the influence of liquor. If you find that the Commonwealth has proven all 5 elements of this charge beyond a reasonable doubt, then your verdict shall be guilty of manslaughter while operating a motor vehicle under the influence of liquor. If, however, you find that the Commonwealth has not proven all 5 elements of manslaughter while operating a motor vehicle under the influence of liquor, then you are to consider whether the Commonwealth has proven beyond a reasonable doubt the 3 elements of the lesser included offense of involuntary manslaughter. If the Commonwealth has proven the 3 elements of involuntary manslaughter, then your verdict shall be guilty on the lesser included offense of involuntary manslaughter. If, however, you find the Commonwealth has failed to prove beyond a reasonable doubt the crime of manslaughter while operating a motor vehicle under the influence of liquor and the lesser included offense of involuntary manslaughter, then you are to consider whether the Commonwealth has proven beyond a reasonable doubt the 5 elements of motor vehicle homicide, felony, OUI, liquor, and negligence. If the Commonwealth has proven beyond a reasonable doubt the 5 elements of motor vehicle homicide, then your verdict shall be guilty of the lesser included offense of motor vehicle homicide, OUI, liquor, and negligence. If, however, the Commonwealth has failed to prove beyond a reasonable doubt all the elements of manslaughter while operating a motor vehicle under the influence of liquor and has failed to prove all the elements of the lesser included offenses of involuntary manslaughter or motor vehicle homicide, felony, OUI, liquor, and negligence, then your verdict must be not guilty to count 2. So I'm going to send in a new verdict slip on count 2 that's just a little bit different, and we have to sort of change the we have to indent something and change the spacing a little bit to make it a little bit clearer for you. Okay, so we'll get that into you in the next 10 minutes. All right, thank you all very much.
Okay, so they've agreed to a change on the verdict slip, which is good. I guess she reconsidered her hasty opinion when she was on the bench before, when she said, this is the way we've always done it in Massachusetts. Yeah, Rhino, agreed. Very glad she decided in the end to make the right decision. These reports are not given to the jury, says Mindy. No, she did not apologize to Janelle for her rudeness. I want to rewind and I want to hear the jury question exactly again because I didn't transcribe it exactly the way it came in. Oh, it's buffering. The internet is broken today.
It's in the case. You won't be receiving any additional.
Okay, here it is.
We're in receipt of your question. Can we request the CERT report detailing the search performed? I take this as a request, and the answer is that you folks, you have all the evidence in the case. So what you have is the evidence in the case. You won't be receiving any additional evidence. But as long as I have you here, I want to clarify my instructions regarding your verdict as to count 2 of the indictment. As I instructed you.
Okay, so she's clarifying the instructions for them, and it is now satisfactory to the defense team and the jury's question. The jury's question was, can we request the CERT report detailing the search performed? The CERT team is the search and rescue team. Who was the witness that came in as the head of the CERT team? They are the team that came in after 5:30 p.m. Had their team assembled. They are the ones who did the grid search, shoulder to shoulder in like a 5-foot line and started finding taillight pieces. And so they want to see the evidence, right? It's SERT. And they want to see it. But they weren't given it. And she said, no, you have all the evidence that you have. And that's all you're going to get. And we're not going to give it to you. Who was the witness that was the head of the CERT team? I can picture him. They came in. They came on the scene. He's the witness who testified that there were some other guys on the scene that he assumed were law enforcement. He was in charge of the crime scene, and he had the command post in his vehicle, and there were some guys on the scene that he didn't know who they were, but he thought they were law enforcement. Do you remember? Why is his name just escaping me right now? O'Hara? Kevin O'Hara. Right. Kevin O'Hara. Thank you, Liana. His name was O'Hara. And he's the one who said, I told them to do a grid search, shoulder to shoulder. And we went along the lawn and we started finding pieces of taillight. And they want to see that report. And there may not be one. there may not be a report. And it says they are considering, I believe, that the evidence was planted. It's interesting because it seems like they want to know, like, what time those first pieces of taillight were found, right? I don't know that we've ever seen that in any pre-trial stuff. And I don't remember his testimony about whether or not they actually logged it. Right. So people are saying there isn't one. They're all bald, so we can't tell the difference. There isn't one. Indie girl's like, the car never hit him. What else do they need? Maybe one person is on the fence and they're like, listen, they did not start finding taillight pieces until the CERT team went in there. I'll prove it to you. Let's get the report and I'll show you. And the report's not in evidence because it's not there. Right, Indie girl? So that was Lieutenant O'Hara of the Massachusetts State Police. He was in charge of that crime scene that was left unsecured from the time Canton PD left at like 8 a.m. to like 5:30 p.m. when the CERT team showed up. And he's the witness who said to them, if you need me to come back after the snow melts, I'm happy to do that, to look for some more evidence. And they didn't call him back. Buchanan testified because he told his guys to just drive by 34 Fairview on the way to work and on the way home every single day because evidence just started revealing itself after that, right? Right? Yeah, he was told to hold off till dark, says Helen. It's all coming back to me now. That's a song. It's all coming back to me now. What's the name of that song? It's all coming back to me. Yep. Karen says that just confirms what AJ was saying about them not making reports. Yep. No reports, people. Thanks, Kim O'Brien. Thanks for being the voice of reason. Yep. Kazza says, hope they keep asking for stuff that doesn't exist. If you're just tuning in, jury came back with a question. And the lawyers have been fighting over the verdict slip because there was no not guilty option on the lesser included offenses on the boxes to check off. The court was very rude during her first conference. And then she came back because there was a jury question and she had, second thoughts about it. So she decided she is going to change the verdict slip. She gave them a new instruction when the jury just came back, and the jury asked a question. Can we request the CERT report detailing the search performed? And the CERT team is the search and rescue team who arrived on scene. And when I say scene, I mean 34 Fairview at about 5:30, 5:46, 5:41, I think was the time that their team was assembled and they started their shoulder to shoulder search. And it was, I believe, Lieutenant, I think his name was Kevin O'Hara, who was the witness who was in charge of that CERT team. And judge said, no, you can't have any more stuff. All the evidence has been provided to you. And it sounds like they're talking about the taillight pieces. Stephanie says, CERT only found 5 or 6 pieces that the Canton PD missed. Then remember, 40 more pieces revealed itself. Yep. I don't even know, was it even 5 or 6 or was it just 3? Because when Trooper Joe Paul did his accident reconstruction, he only had 3 pieces of taillight, right? Because he said that the rest of them weren't important because they found so many other pieces. It just wasn't important for them to find any more pieces. Just wasn't important. Well, the jury got their answer, and no. New members, welcome. Gen X 1968. Michelle Thompson, welcome. Jenna Justice, welcome. I know Michelle Thompson. I wonder if you are she. It's a very common name, I'm sure. Thank you, Janine, for your super sticker. Jam Jar, if the worst should happen, praying not, can Karen get her bail money back to help cover appeals? I would Massachusetts rules are weird, you know? If you're saying if she's convicted and they remand her to jail awaiting the appeal, would she get the money back? Yeah. Let's not go there. She could be also, you know, remanded. She could also be released pending the appeal. That's another option. Bino, thanks for tuning in from Ireland. Judge Bev showed her dislikes and disdain of outside attorneys and let herself down by turning on Karen Reed. Very unprofessional. We've seen it a lot in this case. Dreamer Thinker, thanks for the 10. All we needed was a supplemental instruction. Obvious. That would have obviated the need to call out Karen Reed for smiling, which is understandable since you're adding instructions, Judge. Yeah. She was a little hasty, I think, with that remark. Auntie Oakley, thanks. In Texas, jurors select the foreperson. A lot of jurisdictions do that. You're correct. I'm trying to think how it went in Murdoch. In Murdoch, I think the judge did select the foreperson, and then they had all those jury issues with clerk Becky Hill, who may or may not have improperly influenced that jury way back when. Sir Crash a lot. Thank you. Wasn't Bev the only voice laughing? Sounded like it to me. Barbara, thanks for the 10. Happy 1-year tubiversary. That's what it is. It's like a tubiversary. It's a tubiversary. Thank you, Maureen Francis, for the Cash App, and Patty for the Cash App, and Justin for the Cash App. I think Justin said he got into court today. So he went down there. He's outside the courthouse. I don't know what the scene's like out there today. If you guys are boots on the ground, let me know. There's as many people as were there yesterday. Thanks, Karen said changes are being made. Yep, we just covered that. Thank you. DK, thanks. How improper. She's making these changes during jury deliberations. What she calls minor changes are huge, such as the proper name of the manslaughter charge. This is outrageous. Well, we found the first page to that, D, so don't get upset. The first page was the murder charge. When I pulled it up initially, we had only received the second page. We did go through all 3 pages of the verdict slip. So it was I just didn't have it. I only had the 1 page. Somebody only sent me the 1 page, and we looked at all 3. So thanks, Dee. But those are not going to be the verdict slips anyway. They're now going to be changed a little bit. So good. There needs to be a not guilty option on every single charge, like a little box. You can't just have an option of guilty. It's just unconstitutional. M&T's Yaya, thanks for the 5. So there's no cert report. This is good. Just a reminder to the jury of what has not been provided. That's correct. Janine, thank you for the super stick. Prestige Worldwide. Hey, girl. How are you? Did you have a nice vacation? Thank you so much for the 20. Hear ye, hear ye. I hereby establish the Canton PD Garden Club. This week alone, I anger planted 3 rows of annuals. That's great. I need to do some planting too. I'm glad that you were able to. I don't know. That fan looks like it's shaking again, but we'll see. Allison Cosgrove, thank you so much. They want to know if the search was thorough and should have recovered all or more of the taillight pieces the first time. They are planted. Yes. Indigo Eyes, thanks. Melanie, do you have any thoughts on the significance of the jury's request for the cert report? Does it tell us, if anything, about their thought process? That may be what I just said before. Maybe one of the jurors is like, I want to know when they started searching that cert team, where they found those pieces. What time did they find those pieces? Was it really after the vehicle arrived at the Sally port? Maybe there's one or more jurors who's like questioning why they didn't start finding taillight pieces until the cert team got there. And they're trying to go through a timeline of when the pieces could have been planted, because maybe there's one or more who are on the fence about a car accident at all. I don't know. You can't ever second guess what a jury is thinking or what the questions mean, because you just don't know. There's really no way of knowing. I mean, we could hypothesize until we're blue in the face, but I don't know. Retriever Mom, thanks for the 5. I tweeted our governor that if Bev is too tired to do her job, maybe she shouldn't have it. That's funny. I hear voices in the courtroom. We'll put it right up if something happens. Q McCall, thanks for the 5. The question about the cert team makes me nervous. The cert team never did a report. Sounds to me they're leaning guilty or something. No, may not be. Maybe they're trying to convince one person that, look, they didn't even do a report. So how can we believe anything they say? Ryan, thanks so too. I recommend serving on jury duty. It's fascinating. Yes, it is. I recommend that for everyone, for all my viewers. And also, if you haven't watched Jury Duty on Amazon Prime, go watch it. It's great. It's a comedy about a guy who thinks he's on jury duty, but it's really like a reality show because everyone else in the courtroom is an actor except for him. And it's funny and it's heartwarming all at the same time. It's really good. Wendy, darling. Thank you, Wendy, darling. Oh my gosh, imagine if the jury had to be sequestered. Do they even do that anymore? They do. They do sequester juries. In fact, on that show I'm just talking about, Amazon Prime, Jury Duty, that is, they are sequestered. And James Marsden, the actor, who's amazing, plays himself on jury duty. And he's the reason they have to be sequestered. It's hilarious. Go watch it. But they do in certain cases. I'm trying to think of what the last case, like what the last big case where the jury was sequestered was. If anybody can think of it, let me know. Let's take a look at this breaking news. Thank you to Melissa for sending this to me. Okay, here we go. Thank you. Thank you, Melissa. This is in a public court document. It says all police reports and notes. On February 2nd of 2022, the defense filed a motion in the Stoughton District Court for the preservation of all police reports and notes. The district attorney's office did not produce any notes until September 29th of 2023. Those notes were portions from the Massachusetts State Police. The district attorney's office then revealed that notes from the Canton Police and the CERT team do not exist. So notes definitely do not exist. Does a report exist? It wasn't entered into evidence. I'm going to say nope. Nope. Need some nope emojis in the chat. Nope. The defense has had to fight for even basic physical evidence in this case. Basic stuff. The clothing. To be able to test the hair. Phone records. And they've been arguing for a very long time. Those Bodie lab records about the hair weren't even turned over until the trial already started. Because they did a motion in lemonade, if you remember, to keep it out. Motion in lemonade, as the closed captions once called them. And we started calling the motions in lemonade, the motions in lemonade. Thanks, Crochet Crime 30 for becoming a member. And Allison Cosgrove, welcome, welcome. Susie, thank you for tuning in from Australia and also for your super chat. Marked safe from Lally's boredom. You guys amaze me every day with your creativity of your screen names for YouTube. Thanks for being a member for a month. Good sign that they were looking for that not guilty box. Yep. Matt Bond, also from Down Under. Hello, Spiffy Legal Mumbo Jumbo Talkie sister from another mister. Gonna miss the only fan I will follow. I can't believe it caught on. Thanks, Matt. Thank you, Matt. This is Bucket. Thank you for your super sticker so much. Sir Crash a lot. Thank you. If this trial was a Hollywood movie, I would watch it. I wouldn't watch it. Too fake and unbelievable. Unfortunately, it's real. Yeah. The the reviews would be like, the plot line was so out of left field, it made no sense. I couldn't follow it. This could never happen. That would be the reviews on like Rotten Tomatoes. CERT gave their pieces to Tully, says Double Trouble 247. Yep, they did. Oh, Karen F, thank you so much for the 50. Thank you for the great coverage of this unbelievable case. Prayers for Karen. Thank you. It was so very generous of you, and thank you. Thanks for appreciating it. That was very generous. Thank you. Did they show the part with Bev reprimanding Karen while the cameras are on? I just tuned back in. Yeah, I showed that earlier. That was the first question back in the day. Back in the day. It's only the day. It's still the day. So that was at 10 a.m. I replayed it when I came on at 10:30. And so if you rewind to the back of this stream, I showed it. We talked about it. I played it twice. And then the jury came back with a question, and the judge changed her tune about revising the verdict slip because there was no not guilty option. And then they had a question asking if they could request the CERT report detailing the search performed, SERT, search and rescue team. And remember that Lieutenant Kevin Tully, who testified, said they usually search for missing persons. They're not usually an evidence collection team, right? Did you remember that? Oh, we have over 9,000 people watching. Please hit the like button or I'll put the fan on and everyone will get nauseous. All right. We have 8,900. Nope, we're over 9,000 now and 3,400 likes. So we can do better. We can do better. Hit the like button. Thank you. So thank you. Thank you. Are the McAlberts there? I don't know if they're there today. Did anybody see whether they're walking into the courtroom? Thank you, Mozzie. Hello to Down Under. Bev, tell me I made a mistake without me denying I did. Look the other way. Yeah. Yeah. And did you hear she wanted a decision or like a ruling or an agreement that the original verdict slip was okay so that she couldn't be chastised for it or appealed? She fixed it. I'm sure the jury was confused about it if they even tried to look at it. They didn't say whether they did or not. Yeah. Yeah, Randy, she was reprimanded for smiling in disbelief, apparently. That's right. That is right. Thank you, Scott. Thank you. It says, please hit the like. Show the YouTube community that Melanie runs this show. Thank you. Thank you. Thank you. Nope. Poor Karen is worn out. We're all worn out. Can you imagine how she feels if we are all worn out from watching, talking, and covering this case for so long? How exhausted she is? Like, that's crazy. The jury wants the CERT report. They're not going to get it. Judge says, no, you can't get it. Doesn't exist. You have all the evidence. Suzanne, by the way, they had an MSP escort into court. Why? They don't deserve it. Aiden does, though. Yeah. Yeah. Jemmy K, Brian Albert, and Colin Albert were escorted in there by Massachusetts State Police yesterday. In and out. That's what I heard. My name's Cal. Thank you. I wonder if a juror felt intimidated by the police officer staring. Just approved another year of the chief of police, right? Helena Rafferty's contract, I think, was just renewed. Many are fearful to stand up against the police officers due to retaliation towards grandkids in school and sports. That's interesting. My name's Cal. I don't know if any of the jurors are from Canton. I just don't know. I don't know the makeup of the jury except for that it's 6 women and 6 men. Chad Daybell's jury was sequestered during deliberations. Thank you, M&T's Yaya. I knew there was one that I was thinking of. Thanks for the 5. I don't know how long they took. I don't know how long they took. So while we're here, I'll keep the chat up on my phone in case there's any breaking news. But why don't we take a look at the Howie Carr article from the Boston Herald? Because I think for a lot of you, it is on behind a paywall, so you can't read it. So I'm going to read it to you. And you guys, in the meantime, will watch the cesspool of Twitter. And if there's anything breaking, you'll let me know. But I do have the fan up. It is 12:23 East Coast time. Let's take a look at what Howie Carr wrote yesterday. The article is entitled Reed Case, Theater of the Absurd. And the font is small, so I will have to enlarge it for myself and then read it to you. It's all in the hands of the jury now. But as we await the verdict, think of all the bombshells I can't even read it. Hold on. It's a little blurry too. It's all in the hands of the jury now. But as we await the verdict, think of all the bombshells we were promised by the inept Norfolk County prosecutors that somehow failed to materialize. Ring camera video from a neighbor's house showed Karen Reed killing her boyfriend John O'Keefe with her SUV. Parens fake news broken by a local TV station never retracted. Next, O'Keefe's blood and DNA were found on the undercarriage of the SUV, attributed to, quote, sources. Trooper Michael Proctor had zero connection with the McAlberts. DA Michael, quote, Meatball Morrissey. Proctor did not solicit a gift for his wife in return for his arrest of Karen Reed. Proctor lied about it under oath until confronted with his own texts. Glass on the bumper will match a cocktail glass from the bar, the one that was found on the lawn by his body. More, quote, sources. Of course, Meatball Morrissey and his best band of state police detectives may yet have another opportunity to explain themselves in front of the federal grand jury that's been all over this miscarriage of justice, like white on rice from almost the very beginning. Yesterday, just to add a little more melodrama to the closing arguments, 3 of the leading McAlberts decided to appear in court. One was Jennifer McTooth, the hillbilly hag, oh, that's kind of rough, who Google searched Haas Long to Die in Cold and then deleted the search. But prosecutor Adam Lally had an explanation for that one in his closing yesterday. They were not deleted by user, he practically shouted at the jury. That's not what deleted means. Then there was Colin Albert, the wannabe local thug, son of jailbird Chris Albert. And finally, there was Brian Albert himself, the Boston police sergeant, on whose lawn the body of his fellow officer John O'Keefe was found in January of 2022. Sitting facing the jury, Brian Albert's body language was not good, daring defense lawyer Alan Jackson's closing. His collar seemed to be getting a little tight. For the record, here's what Sergeant Brian Albert has made from the Boston Police Department over the last 3 years, according to city payroll records. In 2021, shortly before Officer O'Keefe's body was found on his front lawn, Sergeant Albert made $244,664, including $78,795 in overtime. In 2022, the year O'Keefe died, and Albert decided to sell the family home, got rid of the family dog, and move out of the town. He made, I think it says, $223,954, including $31,956 in injury pay. Injury pay. In 2023, his pay included $156,400. That included $96,963 in injury pay and $60,464 in other. Living well is not the best revenge. That's a motto to live by in most places in Canton. Oh, that's a motive to live by in most places. In Canton, where Officer O'Keefe died and where all the McAlberts live, they live by different words. In Canton, living, what's that? In Canton, living fat, drunk, and stupid is the best revenge. And an even better revenge is driving drunk in a state police cruiser and losing your gun and badge while you black out. Lally seemed to be mailing it in during his hour, which seemed like a year. Not that he was dealt a great hand of cards to begin with. Garbage in, garbage out. We've been saying that. His most memorable moment came when he mentioned her arrival back at John O'Keefe's because she didn't remove her shoes, as O'Keefe insisted upon. Quote, why is it that the defendant had no issue with wearing shoes in the house when Mr. O'Keefe had that strict rule? Because she knows where he is. She knows he's not coming home. She hit him with her SUV and left him with the snow. End quote. Yeah, that's the ticket. That's how you know she murdered him, because she didn't take off her wet shoes. And then to cover her tracks, she then left 53 voicemails, most of them hysterical, for O'Keefe on his cell phone. Although, sorry, Howie, I don't think that's accurate. I think there were 53 calls. I don't know if they were all voicemails. As for defense lawyer Alan Jackson, he had his theme, and it had nothing to do with shoes. Look the other way. Look the other way, he began. 4 words that sum up the Commonwealth's case. 4 words that sum up the hoax of those who have tried to deceive you. Yes. But what about the deletions that aren't deletions? Quote, late night calls and Google searches, falsified affidavits, inverted videos, butt dials galore. Just look the other way. It's not that it could happen. It's that every single one of those things did happen. Then there was the breathtaking corruption of Trooper Michael Proctor, another low-rent Canton townie who will soon be separated from the state police. Better late than never. Even the troopers union is backing off. From their usual rabid support of every crooked cop. The jury is 6 men and 6 women, and Trooper Proctor must be a particularly hard sell for them, given his astonishing misogyny, calling Karen Reed the C word with no ass and a leaky balloon thing. Lally was at his most pathetic when he tried to explain away these appalling texts to his pals, both from his school and his crime career in the state police. Those were from his private cell phone, Lally explained, without adding that they were turned up by the FBI as part of its ongoing criminal investigation of the corruption in Norfolk County law enforcement. Quote, he never thought they would see the light of day. They were in a safe space for him to discuss, if you will. End quote. A safe space. What was on his mind to discuss was framing Karen Reed. Alan Jackson had a different take. They cannot distance themselves from the stench on him on this case and this investigation. He then elaborated. How did he approach his job late at night in his office, desperately searching for naked pictures of Karen Reed as if she's a piece of meat, calling her vile names? And when he was done betraying that very humanity, he wished her to commit suicide. That, ladies and gentlemen, is how you frame somebody. That is how you rip a person's life apart and sleep like a baby at night while doing it. Jury deliberations continue, but this is only Act 1 of the John O'Keefe murder mystery. Act 2 is already in show. Act 2 is already in show prep at the Moakley Courthouse on Northern Avenue in South Boston. The feds are coming for the Quincy. Nope. The feds are coming for the Quincy hackorama. The Quincy hackorama. There you have it. In today's Boston Herald, the article by Howie Carr entitled Reed Case Theater of the Absurd. Maddie, thank you. Maybe this will be a movie at this point. Plenty of actors and actresses from Massachusetts. I think it's already in the works, to be honest. At least a documentary. PJ, thanks for your super sticker. Michelle, no cert report equals no evidence documented. Boom. Are jurors allowed to take their notebook home? No, they lock them up at the end of the day and nobody looks at them and they're destroyed after the trial. Thanks, Melissa. Some guy with cancer. I'm sorry about your cancer, as always, but thanks for the super chat. Do not insult hillbillies. I know it's not you. Most are better people than Jen McCabe could ever hope to be. Thanks, Emmy Lennon. Did Bev say it didn't exist or they just can't have it? Thank you for your ongoing wisdom. It has been so helpful. OMG, Howie Carr tells it like it is. I took on the Whitey Bulger story, he took it on. He knows about secret gangs and corrupt brothers. Seems that way. Sure seems that way. Oh, thank you, Lori, for the very, very generous Cash App. That is so sweet of you. That is so very sweet of you. Thank you. So what do we got? What do we got? They're having lunch. We have nothing regarding a verdict yet. Let's see what we got here. Thank you, Christopher, for thanking me for doing an awesome job on Venmo. I appreciate you so much. And Tiffany as well says, thanks for the great coverage. Thanks, Tiff. And Jessica, thank you so much. In Lucky We Trust. Thank you so very much for thanking me for keeping you entertained during a medical issue. I'm sorry. I'm sorry about that. Thanks, Ruth, for buying me 3 matcha lattes. And you guys are so generous. Maureen, Francis, and Patty, I thanked you already. And Elizabeth, thank you so much. And Tara, thank you so much. You guys are awesome. So awesome, as always. Here's what we need to do. Let me see something here. Hold on. This could be something interesting. That's something on Steve Nelson. Can't get into that right now. All right, we covered the jury questions. We did everything. I am going to got to do some mommy stuff, you guys. Got to do some mommy stuff. My kids come first. So I am going to thank you, Jen. You guys just be in a holding pattern. When they announce a verdict, I will come back as quickly as I can. If I am not here, it is because I am in the middle of something very important for my kids. So that's what we're going to do. That's what we're going to do. Just keep watching. I'm just going to go live. It's not even going to be like announced, or I may just set up a stream and say I'm coming back as soon as we have a verdict or something else happens. I may not come back if it's just a jury question or something, but if there's a verdict, I'm coming back and we'll be here. Okay, everyone. So everybody just take some deep breaths. We're going to come back. Hopefully it's going to happen today. And until we meet again, thank you, moderators. You're amazing. You're always so amazing. Thank you, Jen, for the super sticker. And just remember, be cool, be kind, be classy. It's not hard. We're on the road here. We're on the road. Keep your eye on the prize. Don't get caught out there in some rando streams and some really vitriolic chat. You're not going to like it and you're just going to be mad. So try and have deep breaths. And as soon as there's a verdict, I'll be back and we'll talk about it and we'll have a celebration. And let's see what happens. Hopefully it's today, but we don't know. We don't know what's going on in that jury room, and we will never know until later. So be cool, be kind, be classy. Peace out. I'll see you later. Keep breathing.